Check out this newest market report on Ripple XRP amid lawsuit tensions. Everything that is discussed in this video is summed up by CoinMarketCap. Don't forget to support my channel for more XRP updates and some other cryptocurrencies overall. Due to the lack of case-related information, the SEC and Ripple dispute did not see any additional advancements on Friday, May 17th. The Securities and Exchange Commission pursued a financial penalty of $2 billion in an injunction that prohibited the selling of XRP to institutional investors in the United States in March, leaving news investors to consider the possible repercussions of breaking our securities laws. Ripple sought a penalty of $10 million. The Securities and Exchange Commission argued in the brief documents out remedies that Ripple continues to violate our securities laws. Ripple countered that selling XRP to authorized investors and through ODL agreements did not violate any U.S. securities laws. The courts must reach a decision, and the outcome may depend on the ongoing post-complaint activities. The case was started in December 2020. ODL contracts, according to Ripple, prohibit investors from making profits or losing money, and sales to accredited institutional investors are exempt from this rule. The CC presents a convincing case that the district judge may consider when determining whether or not an injunction is required, and reasonable investors anticipate that the SEC will file an appeal against the decision on the programmatic sale of XRP in light of the actions that followed the filing of the complaint. According to the ruling made by the judge and Elisa Tor in July 2023, programmatic sales of XRP do not meet the requirements of the third prong of the Ho test at all. The demand for XRP among buyers may be impacted by an appeal. Moreover, a successful appeal could negatively impact the cryptocurrency market overall and give the Securities and Exchange Commission a stronger position to regulate the cryptocurrency business. The courts will next consider the penalty that the SEC versus Ripple case and other SEC proceedings against cryptocurrency companies bring to light the lack of a regulatory framework in the United States for digital assets. Investors should also take into consideration the possibility of an appeal being filed by the SEC against the decision regarding the programmatic sale of XRP.in, the midst of the increasing scrutiny surrounding the SEC versus Ripple case. Investors must pay for violating the securities laws of the United States. In response to a vote on Capitol Hill, the chief legal officer finally said something that both these and ours could agree upon, and denounced Gendler's unjustified overreach in the field of cryptography will not be allowed. A Congressional Review Act that repealed Senate Bill 121 was approved by the U.S. Senate. If Senate Bill 121 were passed, the rule would require businesses to use cryptos that are held by their customers regarding the vote. And companies, including banks, would be required to include assets that are currently in custody on their balance sheets. The Senate's passage of a CRAW that overturns Senate Bill 121, according to Senator Cynthia Lummis, is a victory for financial innovation and a criticism of the way Gary Gensler and the Biden administration have targeted cryptocurrency enthusiasts. It's also the first time that Congress has passed legislation that is solely about digital currency, even though the vote was favorable. This is only the beginning of our journey. Congress has been presented with two measures, one of which aims to encourage innovation, and the other of which seeks to implement rules similar to those found in banking that may impede the expansion of the digital asset area. However, lawmakers in the United States have not yet delivered a regulatory framework that is crucial for the United States digital asset market. Senator Elizabeth Warren was the one who first presented the digital asset anti-money laundering legislation in the Senate. This bill includes suggested frameworks for countering the financing of terrorism, money laundering prevention tools, and CFT. It's noteworthy that Senator Roger Marshall claimed he, Senator Warren, and the American Bankers Association were the ones who came up with the idea for the law known as the Lummis and Gillibrand Responsible the Financial Innovation Act is the second piece of legislation. Senators Cynthia Lumiere and Kirsten Gillibrand introduced the bill, which would give the Commodity Futures Trading Commission the authority to regulate the digital asset market while also protecting consumers. Little progress has been made on either measure, and the US presidential election result will probably have an effect on crypto legislation. Recently, Brad Garlinghouse, the CEO of Ripple, provided a thorough explanation of the ongoing dispute between the Securities and Exchange Commission. He talked about the continuing legal disputes in his presentation, the market projections, and potential disruptions, while stressing the need to fight for legislation and transparency. He expressed faith in Ripple's position against the Securities and Exchange Commission, SEC. Despite the CC's attempts to come to a settlement and paint Ripple in a negative light, Garlinghouse predicts that there will be a black swan event and that the SEC will ultimately fail in their action. According to Garlinghouse's forecasts, the cryptocurrency market might be worth a whopping $5 trillion by the end of the year. His suggestion is to invest for the long run rather than trade, which could cause the price to rise of XRP as the lawsuit's effects start to fade. In addition, Garlinghouse believes that the industry will see anomalous events that he calls black swans, though he doesn't elaborate on what these events might be. He also believes that the Securities and Exchange Commission may start looking into Tether more thoroughly, which could have serious ramifications. Another forecast from Brad Garlinghouse states that cryptocurrency will drive voters in swing states to defect from the Democratic Party because it is a political issue in the US that Senator Elizabeth Warren is pushing them off a precipice. This is something that Democrats cannot accept in full, both in terms of strategy and speculation, but also in terms of the legal proceedings. Attorney James Murphy contends that Judge Torres might reject the CC's discouragement argument, and that Ripple might take use of the court's ruling in the Binance dispute to refute the allegations made by the SEC against its stablecoin. The aspirations, what will happen to ETH and XRP, is a subject of much conjecture in the market, with differing opinions on how it will be positioned within ETH and XRP. This is especially significant because the XRP case is drawing to a close. In contrast, Garlinghouse and Ripple have consistently defended XRP's non-security status in a recent statement, maintaining a firm stance throughout time. Although it is still unclear what the future holds for XRP, the trajectory of its pricing will be largely determined by the decisions made by regulatory agencies, as well as how the project will develop in the future. Garlinghouse reaffirmed this viewpoint and made remarks that would appeal to investors and crypto-efficient cars. Allot Tech H is a symbol of the immense potential of artificial intelligence-powered trading platforms. The dynamic nature of the cryptocurrency market presents a number of opportunities, and at a time when the price of XRP is trying to stabilize, Allot Tech H is poised to make a significant impact with its cutting-edge strategy.